this video, we want to clear up a common and costly misconception. Retirement does not disqualify you from TDIU. Many veterans believe that once they retire, whether from the military, federal service, or a civilian career, they can no longer qualify for total disability based on individual unemployability. That belief is understandable, but it is legally incorrect. TDIU is not about why you stopped working. It is about whether your service-connected disabilities now prevent you from securing and following substantially gainful employment. VA's regulation 38 CFR Section 4.16 says nothing about retirement. It asks a single question: do service-connected conditions make competitive, full-time employment unrealistic? If the answer is yes, TDIU may be warranted, regardless of retirement status. The Court of Appeals for Veterans Claims reinforced this in Ray v. Wilkie, which clarified that VA must look at both economic and non-economic factors. In plain English, VA has to consider more than just whether you technically earn income. VA must also look at your physical and mental limitations, things like your ability to sit, stand, concentrate, interact with others, or maintain reliability and productivity. Earlier, in Roberson v. Principi, the Federal Circuit made another important point. If a veteran's service-connected disabilities reasonably raise unemployability, VA must consider TDIU, even if the veteran never used the words, "I am unemployable." Retirement does not make that obligation disappear. This is where marginal employment becomes critical. Work that earns below the federal poverty threshold, or work performed in a protected or sheltered environment, does not count as substantially gainful employment. That includes situations where an employer makes special accommodations, tolerates reduced productivity, or allows flexible attendance that would not exist in a competitive job market. So if you retired, tried to work part-time, consulted occasionally, helped a family business, or took a low-stress role that still aggravates your service-connected conditions, that does not automatically defeat TDIU. What VA cannot do, by law, is deny TDIU simply because you chose to retire. The focus must stay on functional impact, not personal life decisions. If you are retired and your service-connected conditions now prevent you from working in a meaningful, competitive way, TDIU may still be available. Understanding that distinction can make the difference between a denied claim and the benefits you earned. For more explanations like this, CCK Law's educational blog and videos break down VA law in practical, veteran-focused terms. Take care.